Wow. This has been much anticipated. And ever since the announcement of the retirement of the Honorable John T. Ward, I've looked forward to this opportunity that he would permit us to pause and to do a little retrospective on his 40 years as district attorney, assistant district attorney, a district attorney, and county judge, and to bring back some of the old timers. And you can see from their gray hair or the lack thereof, here they are, you know. And just briefly, let me introduce those folks who may not know them, but just briefly, because it'll come up during the course of the conversation, which will be led by the Honorable Stephen Cass, our surrogate judge of Chautauqua County, who was elected in 1999 and was appointed as an acting Supreme Court justice in 2001 and has served, continues to serve, as the surrogate court judge. All these bios are in the back of the book, by the way. Starting, where's Paul Andrews here, who is next to Neil. Just for our purposes today, in 1984, he was hired by the then District Attorney John Ward as an assistant district attorney and worked under 3 separate district attorneys until 2007, and you'll see him wandering around Lakewood these days.
Walking the dog.
Walking the dog. Next to Paul is J. Kevin Laumer, and Kevin, who continues to be in practice with Pheasant and Laumer and D'Angelo. How many have I said that enough times today, Chuck? Is that okay? Okay. He has served as public defender for the county of Chautauqua for many, many, many years. To Paul Andrews' right, Neil Robinson. Neil, it's not in your bio, but you were both in the public defender's office, weren't you, for a while, and then DA's office?
No, I
No.
was in the district attorney's office.
So at no point did you cross the hall?
Well, I used to go over there and troll for pleas.
We gave him a lot of coffee.
And on the far left there, my far left, Richard Slater. And Richard is a legend. He was assistant to the Chautauqua County District Attorneys from 75 to 77 and was appointed Chautauqua County Public Defender from January 1978 to March of 1998. And we're just thrilled that they all were willing to come back. And let me just, as we introduce the subject in the panel, that His Honor Stephen Cass has spent innumerable hours. And for those who may have been looking for decisions and opinions during the last month or so from Surrogates Court and didn't get them, it's because of this event. So with that, Your Honor, take over. Thank you.
Well, thank you very much. It was once said that men make their own history, but they do not make it as they please. They do not make it under self-selected circumstances, but under circumstances already existing. In our legal profession, as you've seen throughout the day today, what that really means is each particular case has a unique set of facts that the lawyers are handed, and they have to try it. With those facts, make the law. Laws that are still in effect today, laws that affect you and I. What's really interesting is these 5 gentlemen at the table have shaped our future and shaped a lot of Chautauqua County. The stories that you're going to hear today are fascinating, really mesmerizing as I take you back over time. But before we start, for just some housekeeping issues, let me do this. John Ward graduated from law school in 1974, was admitted to practice in March of 75, became an ADA in May of 75. Elected in 77, takes office in 78, elected to the bench in 92, takes office in 93. Paul Andrews, who's right here, was in the public defender's office from 1975 to 1978. He was an investigator. Then he worked for Brandt and Laughlin from 78 to 79, and then he went to law school in 1979, graduates in 82, went to the public defender's office.
Just defense work.
Just defense work
Assigned
with,
counsel.
with Ed Fagan. and then became an ADA.
I learned a lot.
Became an ADA in 1984. Kevin Laumer graduates from law school in 1978, starts in the public defender's office in 1978, stayed in the public defender's office until 98, and I believe he was the public defender from 1998 to 2001. Richard Slater graduates from law school in 1964, admitted in 64. He's in the DA's office in 1975 till January of 1978. Then he became the public defender from January of 78 through March of 1988. And all these dates will make sense to you shortly. Neil Robinson graduates from law school in 1976. In April of 77, he goes into the district attorney's office and stays there until 1996. So let's get started. And the first question really, and then we're going to everything's going to be these guys. But John, why did you go to law school, Judge Ward?
I graduated from the University of Rochester as a history major in 1970. My then first wife's family had a lumber and hardware business in Mayville. And they hired me to work there with the idea that someday I would buy them out and take over the business. After a year of slinging 2x12s in the 0-degree weather, unloading boxcars when it's 110 degrees, 120 degrees inside, and the myriad other things that are involved in running a hardware and lumber company, I decided rather than work for a living, I'd go to law school. I had no idea what I wanted to do as a lawyer. In fact, I have a vague recollection because the environmental movement was taking off at the time as maybe becoming an environmental lawyer. So I applied to several law schools, was accepted at the University of Buffalo, and left the hardware lumber business, went to law school. So that's how that got started.
And then after did you have an internship during law school, or did you?
Between my second and third year of law school, I interned in the district attorney's office under then District Attorney Robert Sullivan. I think it was an 8-year internship.
So Bob Sullivan was the DA, and then you got out of law school, and how'd you get into the DA's office?
What?
8-year internship?
8 years.
8 years.
When I graduated from law school, I was actually hired by, I think the name of the firm at the time was Ledestro, Bailey, and Erickson. And I had not been admitted to the bar yet. And Art Bailey gave me a beautiful office. It was just gorgeous. It was in the furniture building. But he didn't pay me worth a dang. And plus, the things that wound up on my desk were things nobody else wanted to touch. But shortly after I was admitted, there became an opening in May of '75 in the district attorney's office when Paul King, who was an assistant DA, resigned to run against Bob Sullivan in the Republican primary. And someone who I'd met while I was interning in the DA's office the year before was Tony Caprino, who was recovering from a heart attack, and he was what they call the court crier at the time. He was one that raised the court and things like that in the courtroom. And he and I got to be friends. And so when the vacancy occurred in the DA's office after Paul King resigned to run against Bob Sullivan, I think Tony approached Bob Sullivan about possibly me taking the place. And one thing led to another, and I did get the appointment as an assistant district attorney starting in May of 1975.
And how old were you?
I would have been 27.
And Richard was in the DA's office at that time?
No. At that time, it was Bob Sullivan was the district attorney. Bob Seidel was an ADA handling most of the south end of the county. Park Catchpole was also an assistant district attorney. Bill Foley was in the north end. Bob Sullivan and myself. I think that's about the size of the staff at the time. Plus Tony Caprino, who had just been hired. He had been a public defender investigator, and Bob Sullivan had the position created for DA investigator and hired Tony to fill that position.
Now, as I had an opportunity to prepare this, I went and talked to everybody, and Richard told an interesting story when you and he were both ADAs. Can you tell that story, Richard?
Well, are
Put
you
the
talking
microphone-
about the homicide or the gambling bust?
The homicide. Can you put the microphone up in front of you?
Because the first thing that I did when I got in that office, which was January of '76, and John had been there a few months, were these gambling busts. But I think it gets to be around, May or so? And the district attorney was out of town for a weekend. And I get a call at maybe 6 o'clock in the morning to come down to some apartment on 3rd Street. And John must have gotten the same call. I get down there, and here's a guy lying crossways on a bed with an undershirt on and nothing else, and a butcher knife right about here. And at some point, I remember sitting on one side of this guy on the bed, and my recollection is John's sitting on the other side. We're smoking a cigarette, 2 cigarettes, and watching Tony Caprino run around the place doing the investigation, waiting for him to tell us what to do. And that's kind of the way things went in the DA's office in those days. I know this is about John, but he's mentioned Tony Caprino. Tony Caprino was really a remarkable character.
Absolutely.
And in a lot of ways, he was the district attorney in those days, and he may have still been, for all I know. In May, when John got his chance to be hired, it was because Paul King had decided to run an independent campaign against the district attorney, Bob Sullivan. And, I ran that campaign for him, and Neil and I were working down in the same law office at the time, came on board as, I'm not sure if you were even admitted yet at that point. You were still in law school, I think.
I was the treasurer.
Yeah, he was the treasurer.
Good thing he didn't raise much money.
Oh. Well, yeah, or that they didn't bother to check the receipts from the Holland House, which is where most of the money went. When Paul King won that election, he decided that there ought to be a closer relationship between law enforcement, particularly in the South End, than there had been. That was an issue. And the way that happened was that if there was any sort of investigation going on, not just homicides, but anything very large, an ADA was detailed to go. Now, John was full-time. I was part-time. So one or the other of us, and sometimes both, would get sent down to become part of the law enforcement team. And on this particular occasion, we both wound up, and I think we spent the whole day, not together, but going in separate directions, looking all over the city of Jamestown and in some very peculiar places before we wrapped that case up.
So John, then there comes a time that an incident occurs at Hogan's Hut. Can you tell about that?
Well, a gentleman who I had gone to high school with and knew very well was under indictment for a rape that occurred.
No. Back you up. I'm talking about the Sawyer case.
He's talking about Sawyer, not.
You threw a knife at me?
No,
He's talking about Bob Sawyer.
Sawyer.
That happened at Hogan's Hut, too.
Oh, okay.
Start with Hogan's Hut.
The knife incident happened at Hogan's Hut.
Everything
I'm going to make him tell the knife story later on, but right now,
All right.
we're still in the 70s.
Well, I got a call from Tony Caprino saying that there had been a shooting, a homicide at Hogan's Hut.
What year?
This would have been 1977 in February. Paul King was still alive then, but I lived just down the road from Hogan's Hut. And at that time, we didn't have the policy of the DA being there before the body was removed. So we really didn't get called in until the next day. But I was there with some sheriff's investigators and Tony Caprino. And what had happened was, at some time the prior day or evening, Robert Sawyer, the defendant, had come in and held up Hogan's Hut. The victim, who was the sister of a good friend of mine from high school, was 19 years old, and she was a student at JCC. And when we got to the scene, we could see where he had fired one round into the cement floor right next to the register, because there was a crater there, and there were parts of the bullets embedded in the ceiling, the jacketing, the copper jacketing. Then he marched her to the back aisle of the store, made her lay face down, and shot her twice in the back of the head with a .41 Magnum Smith & Wesson revolver. Of course, the body was ultimately discovered, and the expended projectiles were recovered, sent to the state police lab, and the investigator, who is a remarkable individual, had been to probably every firearms manufacturer in the country, maybe in other countries as well. But he came back with a report that said it was a .41 Magnum. He may have given the manufacturer of the ammunition, I'm not sure, but he said something about a left-to-right twist and more than likely fired from a Smith & Wesson .41 Magnum revolver. Well, a .41 Magnum is a very rare gun. Of course, first thing the police did, the sheriff's department did, was look to see who had one registered, and they checked with all of those, and none of those people panned out. But through investigative work, they found out that Sawyer was in possession of a stolen .41 Magnum. And I don't know if you want me to continue with the investigation, Steve, but what happened was they got a hold of a cohort of Sawyer, who was a contractor with Sears Roebuck in Lakewood as a carpet layer. And one of his assistants that he worked with talked with the police and it told them that, yes, he did have a .41 Magnum, and took them out into some wooded areas where they actually did some target practice with it. The sheriff's department recovered the expended projectiles, sent them to the state police lab. The forensic ballistics guy examined them and said they were fired from the same weapon that fired the two projectiles that killed the young girl at Hogan's Hut. So now we had a suspect. We also had, I believe, a couple of witnesses who saw a vehicle leave the scene at or about the time the crime could have been committed, which was a similar vehicle, a Volkswagen Bug, tan in color, that we knew Sawyer had access to, or it was registered to him. But he stole money and he stole lottery tickets. By the time the case was ready to go to grand jury, Paul King had died in a tragic accident on his farm. And Bill Foley, who was the acting DA, had turned over the pending, and there were about 4 pending murder cases in the office at the time. He turned them over to me because I'd worked from the ground up with Paul King on all of them. So I was ready to present on a Monday the Sawyer case, the case against Robert Sawyer to a grand jury, with basically the information that I just had given you. We had no admissions from him. We didn't even know where he was. He was on the lam. But we didn't have much more than what I just explained to you. Other than the fact that there was some evidence that he and the victim may have come into prior contact. He may have done some work at her home on some flooring, and she came home wearing a security guard uniform, where she had worked part-time in some store as a security guard. So there was some information that he may have recognized her at the store. So that was going to the grand jury on Monday. On a Friday, which happened to be my birthday, I get a call from the undersheriff, John Siriano at the time. He said, we did a search of Sawyer's barn with the consent of his wife. We found a duffel bag. Inside the duffel bag was 41 Magnum revolver, as well as lottery tickets, which we have already identified as the ones that were stolen from Hogan's Hut. And I said, John, you just gave me the best birthday present I've ever had. We did not have a chance between that Friday and that Monday, I don't think, to do a test comparison of the 41 Magnum, but it was certainly more than enough since the lottery tickets were linked to Hogan's Hut. The gun was an unusual caliber that the grand jury indicted him for murder, robbery, and whatever else. And I remember after the presentation, because there was testimony that the gun was just discovered and the lottery tickets discovered on Friday, one of the grand jurors, after they'd voted to indict, took me aside and said, were you going to present this case to us without the gun and without the lottery tickets? I said, yes, I was, and I don't want to know what your answer is to what you would have done.
So what happens then, John?
With Sawyer?
Yes.
Sawyer played an incredible cat and mouse game with Judge Adams.
Well, no, didn't you get a call from Massachusetts or Maine?
Maine.
You recognize that, those two things? So I've been through the file, and it's really interesting.
Obviously. He knows more than he does now.
So let me tell you what's really fascinating about this case from another aspect. What happens is they try this case completely. It gets reversed, and you'll hear the whole thing. It comes back again, and Kevin Laumer tries it the second time. They appoint Dalton Burgett, and you'll hear all that. And actually, in the basement of the Jurassic office building, they have some of the files. Actually, over in the sheriff's department, they have the evidence. They still have the blue bag, the bullet casings, the lottery tickets. Pass those down to John.
There goes the chain of evidence.
And it's really fascinating about this whole thing. And so I just handed John one of his notes that he was preparing to present this case to the grand jury before he had the gun. And what do your two notes say on that yellow piece of paper?
Well, I had asked the Sheriff's Department who cashed out to determine the amount of money missing and who supplied the lottery ticket numbers to the Sheriff's Department.
It's kind of interesting. So he's getting ready for the grand jury, and some of those notes are in there. So keep going. So tell what happens with the cat and mouse game.
Well, Sawyer is ultimately extradited from Maine, where he had been apprehended.
But didn't you get a call? Didn't Siriano or somebody get a call about somebody murdered and some receipts? Which one, Richard or Kevin or Paul?
Well, I believe that may have been after, I'm not sure of the timeline, it may have been after he was convicted, but at some point in time, we get a call, the sheriffs do, from the authorities in Maine saying they've discovered a body buried near Portland, Maine. And with the body are a number of sales receipts from Sears Roebuck in Lakewood, New York. And immediately, red flags go up. And so I and a couple of the sheriff investigators go up and meet with the Maine State Police. And it's ultimately determined that he had committed this homicide of this individual whose grave was in Maine, in Massachusetts, conveyed the body up to Maine in the van that he used to lay carpet, and in the process of burying the body, some of the receipts that were in the back of the van wound up in the body. So ultimately, and I don't know if it was before, I think it was after he was convicted in New York.
It was before.
It was before.
It's got to be before.
He was tried in Massachusetts and convicted of that homicide as well.
Well, the interesting part that happens is he's held up in Maine, or Massachusetts, and Ed Fagan goes up there to meet with him.
Well, while he's awaiting extradition to New York, while he's in Maine, that's why I think the New York trial occurred first.
It did. The trial occurred first, yes.
While he was being held for extradition on our indictment in Maine, Ed Fagan, who was the district attorney, or was the public defender at the time, took it upon himself. He had not been appointed or assigned because Sawyer had not been returned to court to be arraigned on the indictment. But Fagan took it upon himself to go up and confer with Sawyer on the extradition proceedings. So when the case came back, and I don't want you, if you want me to jump ahead to what issue that raised, or do you want me to go ahead with the trial?
Well, let's do the trial first.
Because at the trial, he was ultimately returned, okay? He was, because Richard Slater, I believe when Sawyer's returned, was now public defender.
Yeah, I had gone into the PD's office.
You'd gone into the PD's
There was
office.
a big furor about that because I'd been an assistant DA.
And so Judge Adams, in an exercise of caution, even though that we didn't think that was necessarily a Schenkel violation to have a prosecutor go to the defense side, he said, I'm going to build a wall between Slater in this case, and I'm specifically appointing Assistant Public Defender Bruce Carpenter to represent Mr. Sawyer. Bring him into court. Sawyer's there, Carpenter's there, I'm there. Sawyer says to Judge Adams, I refuse to accept the representation of the public defender, but I am not competent to represent myself. And this led to a number of conversations on the record between the judge and Mr. Sawyer as to whether either you accept the public defender I've assigned or you represent yourself. And ultimately, the case went to trial. Adams gave him, right up to the last minute, the opportunity to have Bruce Carpenter represent him, and he said, no, I refuse the public defender, but I'm not competent to represent myself. Put a judge in a really impossible situation. So the judge says, well, by refusing the public defender, then you have opted to represent yourself. So the case went to trial. He had no lawyer. It was a slam dunk for me. He was convicted and went up on appeal. The appellate division reversed, and they basically said that their reasoning was a little bit different than the Court of Appeals, but it had to do with the right to counsel and the fact that he did not make the choice, the judge made the choice that he represent himself. Anyway, it got reversed. We appealed it. It got reversed 3-2 at the appellate division. We appealed to the Court of Appeals. They upheld the appellate division, saying that, first of all, Sawyer did not make the decision to represent himself. Adams did. And Judge Adams did not properly advise Sawyer of the risks of self-representation. And the ironic thing is, at the trial level, before the trial started, Sawyer had a page that he had gotten from an attorney who I believe I know who it was,
I believe we all know who it was.
quoting Gideon versus Wainwright, which was a seminal case about the right to counsel and all that, which led to, obviously, to Miranda. But he was reading from Gideon versus Wainwright all the risks of self-representation, all the things a lawyer can do for you. Reading this to Judge Adams right on the record. The Court of Appeals held, there was no way of knowing that he wasn't just repeating those words, not understanding what they meant, and they may have just been given to him by somebody else and he was reading them. And that was a 4-3 decision in the Court of Appeals, one which later on Judge Saul Wackler, who we all know became disgraced at one time but was a brilliant jurist, was one of the dissenters, and he told Judge Adams that was one of the worst decisions that he'd ever seen come out of the Court of Appeals. So the case now comes back for a new trial. Because of all the publicity, this is one of the only case that I can recall where prior to trial, well, this is a retrial, the appellate division granted a change of venue before an attempt was made to pick a jury.
And that was brought by Kevin Laumer.
That change of venue motion was brought by Mr. Laumer. He succeeded.
Let me just interrupt you here.
Go right ahead.
I remember taking it over and serving it on the district attorney's office, and I gave it to Tony Caprino. It was about this thick, 3 inches thick, and he looked at it and said to me, "What do you want me to do with this? Use it as toilet paper?"
But Mr. Laumer prevailed and got the case transferred to Erie County. Then he made a motion to have me disqualified from prosecuting the case because, as I recall, Ron Gibb had been an assistant public defender when Ed Fagan early on had gone up to Maine to consult with Sawyer, even though he had not been appointed. Judge Marshall, this motion was made before Judge Frederick Marshall, the elder. The son's name, was that Fred also?
Yeah. It's Fred C.
And he said, even though he had not been appointed while he was in Maine, there was an attorney-client relationship established with the public defender's office. Gibb was in the public defender's office. He is now in the district attorney's office. Ward, you're off the case. I'm not taking any chances. And he wound up assigning as special district attorney Dalton Burgett, who tried the case in Buffalo and ultimately succeeded in having him convicted. I don't know if there are any further appeals, but appeals were all exhausted, and about 3 years ago, approximately 3 years ago, I think, Sawyer died in prison.
And before I bring Kevin Laumer back into this, in a politically correct version, can you tell about the jailhouse snitch that was going to testify against Sawyer?
I think I can. There was a fellow who'd been in trouble before who was actually not a bad guy until he was drinking. And I don't mean to sound prejudicial, but he was Native American. And, well, I think we know who he is, sitting at this panel. He had, we heard, and he was a big, tough guy. He was a fighter. He was nobody to mess with, and when he was drinking, he was mean as hell. We had heard that while he and Sawyer, he was in jail, in the county jail on some unrelated charge, that Sawyer had made some admission to him about the killing. So Tony Caprino, now, I think this was even after I'd been disqualified, but Jack Cornell of the state police, who had a relationship with Krause, because Jack Cornell was part Native American, Tony Caprino and I go over to the Cattaraugus County Jail where Gary Krause is being held. He was the individual's name. He's deceased now. He was the witness's name. And we try to persuade him to testify. And he says, no, I'm not a snitch. I'm not a rat. I'm not going to do that. I'm not going to do that. Finally, we persuaded him, look, Gary, you know, we know the kind of trouble you've been in. We know the kind of guy you are. You would never take an innocent 19-year-old girl and do what he did to her. Don't you think it's the right thing to do, to tell the jury exactly what you did? And he finally came around and agreed to do it. So now Dalton Burgett is ensconced at the Adams Mark Hotel up in Erie County. And it is this Gary Krause's turn to testify. So Tony Caprino, Jack Cornell, and I escort Gary up to bring him to Dalton Burgett's hotel room so Dalton can prepare him for his testimony. We bring him into the room, and Dalton has just got files all over the place. And Dalton is pissing and moaning about Fred Marshall and the way he's just making him call one witness after another, way he's on top of them. Don't come up short during the day with the witnesses. I don't care if you inconvenience your witnesses, if they have to come back the next day. He says he's like a wild Indian up there. And the room went dead silent as we all looked over at Gary Krause, who just burst out laughing. Thank God. But as soon as Dalton said it, he knew what he'd done. But anyway, that was just a little interesting tidbit as part of that. And Dalton did an excellent job trying that case. I was up there as often as I could be to get away from my duties as DA to watch him do it, and he did a marvelous job, and very happy for the conviction, obviously.
So Kevin, you bring a motion for a change of venue, it's granted, and you also, I showed you some pictures, contested expectation of privacy due to the search. Can you tell a little bit about that and the trial that happened up in Buffalo?
Well, the challenge to the search had to do with opening up the bag where the gun was found. And I don't know if it's still the law now or not, but you had to put forth some expectation of privacy in the item that was going to be searched. And of course, we're denying anything to do with it at trial, but in order to go through with the suppression hearing, Sawyer had to sign an affidavit and say the bag was his. And at that time, you couldn't use any of those affidavits at trial or otherwise. So it was an odd feeling to have him admit to it as part of the suppression motion.
So you called your witness, you called Sawyer.
Well, I told you that the other day, and as I was thinking about it, I think I ended up just having him sign the affidavit in order to get that into evidence. I can't recall now whether I called Sawyer or not for that, but certainly it was possible.
But I remember you making the argument that his wife gave consent to search the barn. Then she said something to the effect that, I know he keeps certain things in this little cubbyhole area. I don't know if you argued that, but I know you specifically argued when they found the duffel bag, there was an expectation of privacy, that she had no authority to let the police open up a bag owned by her husband. And the court said, no, her consent was wide enough or broad enough to even include the bag that was found. And whether today our appellate division would have upheld something like that, I'm not so sure.
Probably not.
They've become a little less, what do I want to say? I don't want to say pro-prosecution, but they did not suppress it.
So is that a photograph of the barn and the
I don't know.
cubbyhole?
I can't imagine.
Yeah, there's a photograph there of the barn, but he had sealed up this area with some barn boards and nails and stuff like that.
Right.
Yeah. The interesting thing about the Sawyer case had to do with his ability to escape. When they brought him back from Maine, they took him inside of the garage behind the sheriff's department. Now, when he was last in Chautauqua County, they didn't have a garage, and they would let defendants, get out of their cars, and then they would walk through a door. So they were actually out in the open when they got out of the car. Now, they changed that. So when he was brought into the garage, his handcuffs were off, and he had the key for them, and he handed them both to the deputies that had brought him there. So that was his first attempt at escape. The second one is I got a call. He was up in Erie County, and they told me that a off-duty jail guard was walking out to his car, and for whatever reason, it was nighttime. He turned around and looked back at the jail building there. It's in downtown Buffalo, and he saw a shadow up in this window, and he realized that window was the second-story window of a cell block, and that this was from the floor of the cell block, you could go all the way up to the second-story window. And it turned out Sawyer was the person in the window, and he was up there with a hacksaw hacking away at the bars on this window. He had already gotten out of the cell block by using the hacksaw, and now he was up there, and they said he was just a short time away from being able to get out and escape through that window. I don't know how he would have gotten down to the ground from there, but the fact that he had a hacksaw, it was always a mystery to me. I don't know how they ever, if they ever found out where it came from or not, I don't know.
I don't know, and I don't even know if they're sure where that handcuff key came from. Apparently, when they arrested him and handcuffed him, he had it secreted under his tongue. And somehow during the ride from Maine back to Chautauqua County, he was able to get that key out of his mouth and into the handcuff lock and unlock and free himself.
And during the second trial, Kevin, what do you remember about Sawyer? What was he like? I mean, you met with him every day.
Well, Sawyer was, he was a very calm individual. I mean, he was cooperative. He never gave me a hard time about anything. So, you know, he was actually an easy client to represent. But he certainly had some major issues.
Do you remember do you remember during the second trial, the owner of the gun?
Yeah, nobody ever knew where the gun came from, who had owned it, other than, as John said, they thought that Sawyer had stole it. Well, during the middle of the people's case on the second trial, we had a little hearing in front of Judge Marshall, and he told, Dalton told him how they had gotten a phone call from an individual in Warren. And he said, you know, I think that's my .41 Magnum. And he said, I just was reading the stories in the paper about the trial, and I recalled that a guy from Sears had been taking or putting in carpet in my house. And of course, that's what Sawyer's job was, a carpet layer. And he said, after that, I then discovered that the gun was missing. So they brought him in, he identified the gun, and that was just another tie into the gun and brought Sawyer even closer there to what was going on. And quite frankly, you know, John's, you know, not to diminish the role of Dalton, but I mean, Dalton basically followed the outline that John had done in the first trial, and the evidence, you know, as it went in, and especially as they added Gary Krause and the owner of the gun, really became overwhelming.
And Paul, did you testify during this trial?
For some reason, I got called up for the suppression hearing and the trial. Basically, I spent 2 hours out in the barn looking at everything and talking with his wife, because I was in the public defenders at that time, and Mr. Fagan told me to go out and do that. So for about 2 hours worth of work, I ended up sitting up in Erie County Courthouse for a couple of days, thanks to Kevin. And there really wasn't much that I could add or detract from the case.
So before we move to the next one, John, you had been the DA for 6 months when you're trying this case?
No, Sawyer went to trial, he was
78?
indicted in June of '77.
You were elected in 77 and began.
I was elected, I took office in January of '78, and it wasn't, there was some time before the extradition proceedings were concluded. He was indicted in June, I believe, of '77. And I can't remember, Richard, when actually the first trial was that we had here in Chautauqua County before Judge Adams.
And then for my segue,
But it was sometime in '78, I believe.
I'm going to have Neil read this little article from the Chautauqua News. Can you give a date on it, Neil?
February 24th, 1977, and has Nettie Ward on the front page. Deep investigation and murder of young Stowe girl continues. Investigators of the Chautauqua County Sheriff's Department, state police, and law enforcement officers from throughout the northeastern section of the United States today were continuing an intensive investigation into the Jeannie Hum murder of Friday, February 11th. Miss Hum, 19, a Chautauqua Central School graduate of last June, and an honor student at Jamestown Community College, was found on the floor of Hogan's Hut at Stowe shortly after 6 p.m. by a neighbor. Police said Miss Hum was killed by 2 shots from a .41 caliber Magnum.
And I'm going to stop you right there. So now that's February of '77. This is before Paul King has passed away. And it's really interesting that this Chautauqua News, Neil, can you read that little bulletin that I showed you? So here, John Ward, soon to be the DA, runs across another problem. You read the bulletin?
Bulletin. The badly frozen body, described as that of a young girl, was found along the railroad tracks at Westfield shortly before 9 a.m. Wednesday. Still unidentified at 1 p.m. Wednesday when this paper went to press, the remains were ordered taken up to Meyer Memorial Hospital in Buffalo, where coroner Anson Stewart of Dunkirk said an autopsy will be conducted. Although not coming from official sources, it is believed the girl's body had been there for possibly several days.
And what case was that, John?
That was People versus Fillmore Scruggs.
And tell us the story.
Well, as the article said, the body was found by a citizen, I believe, reported to the Westfield police. They called in the sheriff's department for assistance. The autopsy done at, it's now called the Erie County Medical Examiner's Office, but back then it was at Meyer Memorial Hospital. And it was done by a Dr. Judith Lahote, who was Hungarian, and she was one of the most fantastic pathologists, medical examiners I've ever come across. She would even come down to Chautauqua County to a crime scene if we asked her to look at it. But Fillmore Scruggs was a pimp from Erie, and then this young girl had gotten associated with him. And the police in Erie, Pennsylvania, that's not Erie, New York, Erie, Pennsylvania, when she was identified, and I can't remember exactly how it was, whether it was photographed, she was partially decomposed, but she was identified, and the police put 2 and 2 together pretty quick in Erie. They knew Scruggs was a pimp, they knew he had a lot of young girls working for him, and it wasn't too hard to make the connection between the two of them. So he became a prime suspect, and as part of the investigation, the Erie police obtained a search warrant for Scruggs' apartment on Parade Street in Erie and found a number of incriminating items, including a pair of pants, blue jeans, that ultimately had her blood on it. Now, back then we didn't have DNA testing. We had the ABO markings, and we had certain genetic markings where we could bring it down the probabilities into the hundreds of thousands, but not into the billions like they can do today with DNA. But still, it was fairly convincing that it was her blood. And so we put together all the evidence we could and got the indictment, and ultimately the case went to trial.
And what happens throughout the trial? Who represented him?
He was represented by, I believe, Bruce Carpenter. And their defense was, and I'll let Paul go into this a little bit because it's kind of interesting what he had to do. Little sidelight, for some reason Fillmore Scruggs took a hating to Tony Caprino. Tony would assist me in all major trials. He would sit next to me, he'd have the file organized, we'd go through it beforehand. In each folder would be the witness's statement, any items of evidence that I had to get in through that witness or lay a foundation, whatever. So Tony would always be sitting between me, and Scruggs would just be staring at him all the time. For some reason, he hated Tony Caprino, called him the chunky flunky. And if you know Tony, he wasn't that tall. But anyway, one day we're getting ready to take a recess, and the file is in a big cardboard box. And as Scruggs is being let out, he goes right behind the prosecution table, and he takes a swing at Caprino, who immediately holds that box up and deflects the punch. As it turns out, the jury was leaving the courtroom, and at least 2 or 3 of them heard the commotion and turned around and saw what happened, which didn't hurt our case that much. But I'm sorry, Steve, what was the other thing that you...
No, keep going. You're doing great. I can't wait to hear
the whole defense, and I'm going to defer to Paul a little bit about this because he was part of the defense team. But the whole defense was that she did not die in New York, because under the criminal procedure law, death is presumed to have occurred where the body is located. The body was located in Westfield. It was determined she'd probably been there for about a week. Her body frozen, thawed, frozen, thawed. I believe somehow, Paul, and I can't remember how, but I believe there was blood found in the trunk of Fillmore Scruggs' car. But the defense was that she was shot in Erie in his apartment. She died in Erie, and therefore New York had no jurisdiction. And when it became apparent that that was the defense, is that she didn't die in New York, that she died in, it's a presumption that can be overcome. Presumptions can be rebutted. I said, when it became that was apparent that was their defense, I leaned over and I said, Tony, do you think this jury gives a shit where she died? He said no. So anyway, Paul, tell them about your...
But before I bring you to Paul, I got to show you this new little caveat that I found, which is really interesting, because under Paul was an intern in the public defender's office who had to go visit Fillmore every day. Kevin, tell him what happened.
Oh, Kevin.
Well, I was a law student, and I was working down there in the public defender's office, and Ed Fagan was in charge at the time. And he gave me the task of going over to talk to Fillmore every day. So I had to go over to the jail and meet with him. Well, shortly after this started, I was able to converse with him, and he was, easy enough to talk to. So he asked me to bring him a pack of gum one day, and I said, well, I don't have any. He says, well, bring some back the next time you come. So the next time I came back, I brought him a pack of gum. And then a few days later, I found out that there was gum in all the locks over the jail, and that the possession of gum was contraband in the jail. So I think my first admission of this was to Steve the other day.
Statutes run.
But this is even more incredible. So, Paul, tell what you did. So, what do you remember about Fillmore Scruggs?
Well, you have to understand, Kevin got to go over there every day because Fillmore was such a miserable man that no one really wanted to talk with him. So as you know, the intern gets the best job in the office.
Now, remember, Paul is an investigator in the public defender's office representing Fillmore, and the attorney was Bruce Carpenter?
Correct.
So tell what happens, Paul.
Well, Bruce finally realizes, and in his heyday, Bruce was an excellent trial lawyer and did excellent research, but he was somewhat controversial in his tactics and his techniques. But
And he sure knew how to get under Judge Adams' skin.
and before, as we're talking about these cases, all these times, there's always an undercurrent here of with Judge Adams. And if those of you who know him can now put a mental picture of him trying to talk to Sawyer or Fillmore and and his face getting red, and he's pounding the pulpit, and it's just unbelievable how uncontrollable he could become with Bruce's egging on. But and he would realize it afterwards, and he would say, "He set me up." Yeah, but it's on the record for whatever he said or whatever. But in any case, Fillmore Scruggs is now sitting in jail. Bruce, as an assistant, is assigned, actually, because we still got this undercurrent issue going on with the public defender's office, and Fagan not actually being assigned officially by Judge Adams because of his, quote, inexperience. That's for another day. When we finally realized that there's really no other defense here, Bruce tells me to go over to Erie, where Fillmore's apartment is, and look in a particular spot and test for blood. And if I find the presence of blood, do what I can to get a sample of that together with the rug. I can't remember if it was a subpoena ducis tecum signed by Bruce or a judicial subpoena that we were able to get Judge Adams to sign, but I took that and I went down to the county clerk's office and I had gold seals put all over it. And Lefty Nelson was a part-time investigator. He had been in the Jamestown Police Department. He happened to know people, a person over in Erie County with the Erie County Police Department. And we went over there because we weren't getting any discovery from the DA office at the time. And he prevailed upon his friend who brought us the whole police file in the middle of the night to the Holiday Inn, the old Holiday Inn down in Erie, where we finally were able to put everything together and exactly find out what was going on. And the police could not figure out how we knew what we knew at that time. And we weren't talking. And I think it's probably the first time I've probably said that other than to the judge. But in any event, we'd hang out around Perry Square, talk to all the pimps, talk to all the prostitutes, background, go into some of the bars. But I had to take the subpoena, and I had to go to his apartment, and by then the apartment's been rented out to someone else. And we knock on the door, and I took the chemistry professor, he was actually Robert Kokersberger, if you knew him. He went with us, and we presented ourselves to the tenant, presented the subpoena, and we were able to talk them out of taking the whole carpet. Now, this is a living room carpet, which is probably, if you roll it up, it's about as long as this table and about as round. But Bob Kokersberger tests the area that Bruce tells me to look in, and sure enough, there's a presence of blood. Now,
And Lyle, here's where we go to the chain of custody.
so we have this carpet, and at that time I was living in DeWittville, newborn baby, yeah, I think so. And guess where the carpet ends up? In my guest bedroom at my house for that night. And then I have to take it up to SUNY Buffalo and speak to someone in the lab area who can test that that blood to determine first if it's human, and then the breakdown, what the AV antigens or however that was. And they were able to do that. And so now we have a case, technical though it may be. And when it becomes apparent what we want to do in front of the jury, John calls for a recess and asks for an offer of proof. Well, then I'm testifying, and for some reason, the judge doesn't let it in because of some chain of custody, or it's not in the same condition as it previously was.
Could have been contaminated in the meantime, all sorts of things.
Yeah, we knew which way that was going to go anyway, I think. So, and Bruce was an excellent appellate lawyer, you have to understand. So a lot of things that he did, he was trying for the appeal as well. So, but that was the extent of it. He obviously, I was there when he jumped Tony, and we're going down the hallway afterwards, each one of us carrying our boxes, and Bruce telling Tony, sorry about that, didn't see that coming, I owe you one.
So John, it goes on.
Ultimately, he is convicted. And I believe back then the Public Defender's Office did its own appeals. Now the Appellate Division is assigning out, usually outside counsel. But he was convicted, and they appealed. He was sentenced to 25 years to life, which was the maximum. So after, I don't know how, the appeal maybe takes a couple of years to perfect and everything, and one of the issues on appeal was the search warrant that the Erie County, Pennsylvania police had obtained from an Erie County judge, that the wording as to the areas to be searched was too broad, that it allowed search of other apartments that he may have had access to. And the Appellate Division said it was too broad, therefore anything seized pursuant to that search warrant, including the bloody pants, which was a big part of our case, suppressed, new trial. So I had to call the family of the young girl, the 19-year-old girl, who, by the way, she came from a very nice family. I don't know how she I may have heard the story from the parents, I don't remember, but they were very nice people, and I had to call her father and say, so the case has been reversed, there's going to have to be a new trial. Then I get a call a little while later, and I'm not sure who it was from, but when the public defender's office, and this is no slam on the public defender's office, because they just normally would go about, do everything they need to perfect the appeal, get it argued. If they win or lose, they would notify the defendant whether they won or lost. They called to notify in Attica Fillmore Scruggs that he's got a new trial and find out he's been dead for over a year. So I called the father of the victim back in Erie and told him that. And I don't remember who the public defender was, and I'm not casting any aspersion.
I was public defender, but we were just trying to remember who handled it.
Yeah, and I mean,
Wasn't either of us.
it wouldn't have been normal course of business unless there was something they needed to discuss with the client, and this was strictly an issue of the search warrant. So anyway, I called the father of the victim back and told him that, there will not be a retrial, that he has died in prison. And he said, John, this is probably one of the happiest phone calls, as sad as everything around it is, that I've ever gotten. And I'll never, ever forget that. And I'll never forget, a few days later, there was a big headline in the Jamestown Post-Journal that said, Fagan says Scruggs dies an innocent man.
And before we move on to the next one, so Scruggs gets convicted, he's in front of Judge Adams for sentencing, and what happens?
Well, Scruggs, and I'm paraphrasing now, Scruggs said something to Judge Adams to the effect that he wished that there were a death penalty in New York. So when he was sitting there getting ready, wished there were the death penalty, electrocution. So when he was sitting there and they pulled the switch, that Judge Adams could be sitting there in his lap.
He was a miserable man.
He was miserable to the end.
So here's an interesting case that I haven't prepped any of you on. And Richard Slater had been trying felonies, and he had a great record, and he thought that he could try and win just about anything. You want to try to tell that case, Richard?
Well,
And I'm going to stop you in the middle of it because it's got an interesting
About,
story as well.
end of 78, early 79, we talked about, I guess we talked about it out here, there was a really brutal murder in the city of Jamestown, and ultimately the fellow was arrested, was an ex-Marine, very young ex-Marine. And Judge Ward and I tried that case pretty much on the scientific evidence. A lot of circumstantial evidence, crime scene investigation type stuff as it existed at the time. We didn't have DNA in those days. They looked at the antigens and the blood types and so on and so forth. And up until that time, I had never had a county court jury come back with anything other than what I'd asked for. When I was in the DA's office, it was always guilty as charged. When I was defending cases, they were straight acquittals, except for a couple of cases that Judge Adams decided they didn't trust the jury on, and he was going to deal with it right then and there, which happened a couple of times when I was in the DA's office.
Now you understand how difficult it was for me to deal with him all the time.
I honestly believed I could win anything. And we tried that case for probably 3 weeks. Just tons and tons of evidence. And I think the jury was out 45 minutes. If that. If that.
Carlson you're talking about.
But,
Yeah.
I mean, they didn't want lunch. They didn't want a cigarette break. They just came.
I don't know if you remember this, Richard, but you expected us, the victim was married. and she'd been stabbed about 70-some times by the defendant. I think he picked her up in a bar, and what led to it, such rage, we don't really know for sure. But I think Richard expected us to call the husband, and he thought he could get some pretty exculpatory stuff out of the
I
husband.
wanted that husband on the stand.
And
I kept fighting the identification of the woman, just try to get the husband up there.
Caprino and I finally decided it's not going to do any good for us to call the husband. We don't call him. So Richard calls him.
Yeah.
And he starts treating him like a hostile witness and tried to ask him leading questions and everything. And I don't know what it was, and I objected. And Richard says to Judge Adams, well, this should really be a prosecution witness.
I want him to be a prosecution witness.
Richard, tell
I'll
what
tell you
happened.
one thing about that case, and I think John will remember that. The crime scene was out in a field, and there were some bushes, and this woman, like, she was kind of maybe not middle-aged, but 40-ish,
Yeah.
as I recall, and she wore glasses, and the glasses weren't there. And the police looked for the glasses, and Tony Caprino looked for the glasses, and nobody could find them, and there was some thinking, I think, over on the law enforcement side that maybe the absence of these glasses was going to be significant. And months after the investigation, when we get to trial, and in those days it used to take about 8 months or so to take a murder case from arrest to trial, we're putting in proof, and I don't know who it was,
Jim Burns.
picks up a photograph
Oh.
of the scene, which included the bushes, and there, if you look, clear as a bell, with the glasses sitting in the bushes. And I can remember Caprino just elated to know where those glasses were. Because there was a loose end that had been bothering him.
Now,
They did
now
retrieve
Richard, tie up the one part about the marital exemption and the proof and Manley Anderson.
Oh, God. This kid had associated himself with a wife who I think probably had about a third-grade education and had been hanging around the Marine Corps base doing whatever came naturally. And he married her. And the theory on the prosecution side was that when he came home that night or early morning, that she could provide some evidence as to his condition or his statements or whether he was covered in blood or whatever. And the district attorney decides to put her on the stand to testify to whatever that might be. Now, my belief was that a wife could not give testimony against her husband, and the way this was going to get resolved was we were going to have an offer of proof outside the presence of the jury. Well, I didn't like that much better either, because whatever she said, they were going to hear, and it might lead to some other evidence. Somebody here mentioned that on very rare occasions, Judge Adams used to
Pound
show
the
a little
bench.
color in his face and perhaps become a little agitated. And we had this offer of proof hearing, which probably lasted 45 minutes, and I don't think I sat down. I was just up saying, object, 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 object. And we kind of got the color of the rainbow, and the judge was, he did know how to affirm, because anytime John said something, he affirmed it.
That's where I learned it.
But all of my objections were for naught. And it just kept getting worse and worse and worse and worse. And it got to the point where he was right about on the verge of maybe using the contempt word.
Hey, if I can just interject, the wife of Roger was somebody that we brought up here and put into an apartment above the liquor store in Mayville so that she could be around to be used. And Frank Bajano and I talked to her about being prepared to sit in the courtroom and, make a good appearance. She was a very, very simple woman. I think she was from the hills of Kentucky or
I don't
something.
think she owned a pair of shoes till she
Yeah.
was 19.
So we told her that, she should dress up a little and look good for the trial, and she did. She showed up in a full-length prom dress and sat in the front row, and it was a spectacle, to say the least.
And I don't remember which trial this was, Richard, but we had a number of cases where we tried, cases against each other, and we had a mutual respect for one another. And I remember we were sitting waiting for a verdict after, I don't even know which case it was. The judge has charged the jury now. We've already given our summations. The judge has charged the jury. They're out, and we're waiting for a verdict. And Richard comes over to me and says, John, I spend a half an hour during my summation trying to draw sympathy out of these jurors, trying to get them to feel some emotion for my client, doing anything I can to get some type of emotional response from them. And then you get up and remind them of the facts.
So, Richard, finish your thought. What happened with Manley Anderson of the Post-Journal?
Well, I came out of the courtroom, and I was really steamed. And we had the reporter from the Post-Journal, was named Manley Anderson, and he was an old-time reporter. He came to every trial. He actually reported what went on. He didn't take a telephone message from one of the lawyers telling him what it was, and he knew pretty much what he was seeing in front of him. He got it right. We used to have two of them up there, one from Dunkirk and Jim Fox and Manley, and they were professional type reporters. And I walked out of the courtroom doors into the hall, and Manley said, "What did you think of that?" And I said, I don't know how I want to phrase this, but I used a term which involves who your mother was and kangaroo court. And I remember those two phrases came together. And they weren't about the district attorney. They were in reference to the decision maker. And Manley said, "Oh, I understand." And he walks away with his pencil and his pad in his hand. And when he started down the stairs, my brain started working again, and I realized that I was looking at about a week in jail. And I caught him at the front door, and I said, "Manley, you can't print that. If you do, the judge is certainly going to, he threw Ed Fagan in jail for far less than that."
It's a railroad job and a sham and a mockery.
Yeah,
of
well,
justice.
I know, but I think the heredity phrase would have done it. And Manley was a great guy, and he didn't. And the newspaper article later said public defender Richard Slater was visibly upset.
So, John, I've just handed you a picture. Do you recognize who that is?
Sure, Brian Blanco.
It's interesting because it went down through, everybody kind of looked at it and couldn't put it together. What I found fascinating about that photograph as I went through his file is John went through with almost like a photographic memory, and he said, that guy had a nice leather jacket. Mm-hmm. Did you remember you said that the first time? And in that picture is his nice leather jacket. Tell the story of Brian Blanco and what happened.
Well, Brian Blanco, and this had to be early 80s. I think the trial was like in 1984, so let's say it about 83. He abducted a young woman coming out of a Rite Aid drugstore in Jamestown, forced her into her own vehicle, drove her out to a remote area in the town of Gary, and proceeded to beat and sexually assault her over a period of hours, and ultimately locked her in the trunk of the vehicle. It was her vehicle, and left. And in the meantime, her husband had notified the police that she had not come home, so they were out, be on the lookout for a car with these plates. The next morning, I think this was in April of, 83, and it was very cold. The next day, the owner of the property out in the town of Gary was just walking along, I can't remember the name of the road,
28 miles.
28 Mile Road?
28 Creek Road.
28 Creek Road. And he owned some property, it was a long driveway, and he owned the property back in there. But he had no intention of going back there until he saw the sun shining funny. There was a funny glint of light that he had never seen before. So he decided to go back and investigate, and he found the vehicle there. And went back and reported it to the police, and they came, and the police saw the vehicle, and they, didn't really do much other than confirm that the vehicle was there. And I believe when the individual who saw the vehicle, who owned the property, was there, she could hear him walking around. Now, he was a friend. He would have helped her. But she kept quiet because she thought it was Blanco coming back to assault her again. So then the police get there, and they bring her husband. And she hears her husband's voice, and at that time she starts pounding on the trunk. And they open it up, and they find her naked, wrapped in the trunk liner of the car. And kind of a sad part of the story is two people witnessed the abduction. They heard her screaming. They saw him push her in the car. They even followed the car for a while till they lost sight of it. They came back and they reported what they had seen to a Jamestown police officer who was busy, I believe, on a traffic detail at the time. He said, all right, it's probably a domestic dispute, but I'll call it in, when I can. Well, he never did. And whether or not that would have led to them finding the car in time and preventing the crime or not, I don't know. But Blanco was ultimately convicted of, and we actually got, and it got by the appellate division, a first-degree kidnapping out of that. And I can't remember what the elements of that were, but that's an A1 felony, and that carried a 25 to life. And I believe Adams, on top of the kidnappings and the robbery and the rapes and everything else, I believe Adams gave me the 22 or 23 years to life. And he, within the last couple of years, passed away in prison. But the victim and her husband brought a civil suit against the city of Jamestown for, I don't know, negligence. I don't know what the exact cause of action was, but for the failure of the police officer they notified to take further action. And it went to the appellate division and the Court of Appeals, both of which held that since she herself had not reported it, she herself had not complained to the police, it was a third party, that the police owed her no special duty, and therefore they were not negligent or whatever the proper term is, and they upheld the summary judgment that was initially issued in the local court. That was, of course, all a civil case, but I know the police officer was so distraught, he resigned immediately. And but that was a very interesting case, very strong woman to have survived what she did. If she had been in that car another 24 hours, she would not. She would have frozen to death.
And Kevin Laumer represented Brian Blanco. But Kevin, could you address the civil cases just for a minute before we go on to some of the testimony in the trial that occurred?
Well, as John was saying, you had to invoke some sort of special duty and create this relationship between the victim and the police. And not too many years before that, up in Buffalo, there was a case called DeLong, where the lady had called the police because she heard an intruder, and it was a daytime intrusion in the morning. And she called the police and said, send somebody over here, there's a burglar here, and she gave them her address. And the police sent a car to that address, but in the wrong town. And they ended up finding Mrs. DeLong eventually dead in her driveway. She had been stabbed repeatedly. So that was the distinguishing factor with this case, in that this woman did not have that direct contact like the lady in DeLong's case did.
And I remember the dissent in the civil case very strongly said, how could she have had contact? She was under the control of Blanco. These people were, in fact, they didn't call them agents, but they were conveying what they had seen, which basically is her calling out for help. They conveyed it to the police. Therefore, there was a duty on the police to follow up. But by a majority decision, the Court of Appeals said no.
What kind of proof did you have at the trial to convict Brian?
Her identification was basically.
Any fingerprints or palm prints?
There were, on the trunk of the vehicle, we had an FBI fingerprint expert come in and testify that there were fingerprints on the trunk of the vehicle. She could not testify how they got there or anything, but it wasn't much of a stretch for me to argue when you saw the picture of how they dusted and where they were located, that it appeared that there were the fingerprints of somebody who slammed the trunk shut, and they were Brian Blanco's fingerprints.
So here's an interesting story. If you could bring yourself back to our county courthouse, back in what year would that have been?
He was tried in, I believe, 84.
1984, and there is the FBI agent testifying. Kevin, can you take it from there?
Well, Mr. Blanco was not a real cooperative individual throughout this process. And the FBI agent was down here testifying. There had been two FBI agents actually coming to testify, one on hair analysis and the other one on fingerprints. And it's my recollection there were actually more than just the prints on the hood of the trunk. I think they had inside prints, they had side door prints. I mean, they were everywhere. Right. Brian did nothing to try and cover this up other than leave the scene. So John is laying the foundation for the introduction of the fingerprint evidence using this female FBI agent that they brought from Washington. And of course, he's laying it on real thick. He's going real slow, and he's building to this giant crescendo, and it's going on and on and on. Finally, Blanco stands up, and in a voice that everybody could hear, says, "When's my lawyer going to ask the bitch some questions?" So, Adams, of course, he was probably pretty pleased that happened, I think, and he cleared the room and sent Mr. Blanco out into the holding room and conferred with us, and then brought him back, and I thought he was going to leave him in the holding room, but he actually had let him come back and sit in the courtroom at that point. Yeah.
Well, I remember one thing you had Frank Pagano, who was your investigator, on the stand. And one of the things that the victim had neglected to point out when she was identifying Blanco was that he had a scar over one of his eyes. And I was cross-examining Frank Pagano about it, and I don't remember what the question was, and Frank says, "Well, I've got a pair of magnifying glasses in my pocket right here if you want to take a look for yourself." And I just looked at him, shook my head, and sat down.
The Blanco case didn't end, for me until last year, and it was a bit of a surprise. I got a letter from the Department of Justice, and I think the DA's office also got one. I don't know if you were aware of this or not, Judge, but the Department of Justice had been involved in a big lawsuit with the Innocence Project about FBI agents, and they refer to them as kind of rogue FBI agents. And in this case, the guy that did the hair analysis went beyond the scope of what the FBI felt he should have done and what the Innocence Project felt he should have done, and now the Department of Justice agreed that he had gone too far, and they wanted to know where Brian Blanco was and what we were going to do about this. And of course, as John said, he was dead at that point. But
well, as you recall during the trial, the motive we argued to the jury was that he had just had a very serious argument with his wife. And this was a crime of as much anger and rage as it was of a sexual nature. And when it finally got around toward the end of the trial, which I strategically decided to call his wife to the stand to talk about what had happened in the few minutes or hours prior to the abduction. And when she walked in the courtroom, you could have heard a pin drop because she was almost a dead ringer for the young woman that he had kidnapped. And she just happened to be in the wrong place at the wrong time. And he saw her, pushed her in the car, and did what he did.
Interesting
Very
enough.
Brutal, bad man.
Both Brian Blanco and Robert Sawyer died in prison in July of 2013
Of natural causes,
of natural causes. So,
according to the Department of Corrections.
So, John, I just want you to go back to the original Hogan Hutt story that you were going to tell to start with, which is, I asked John, have you ever been assaulted or attacked by any of the people that you prosecuted over the years?
Well, when I mistakenly started before, there was an individual I'd known from high school, and he was under indictment for raping a young waitress who worked at the Good Morning Farm in Stowe, and she was walking her bike or walking along the road, and she was grabbed and dragged down by a creek off of Route 394, which ran differently than it did now. And it was some 2 years later, I believe, that they put the case together. And in the meantime, the suspect had been in a bad automobile accident and suffered some brain damage, had a plate in his head. But she made an identification, and I can't remember, and I'll let Neil talk about this more because he prosecuted it, because I was involved in another homicide case. No, you didn't prosecute. Yeah, you prosecuted. He prosecuted it because I wasn't sure I could win it. So
That's how Neil got all the cases. That's how I got all the cases, too.
I got all of them.
in any event, it was an issue of identification. She was quite sure that this was the individual, and it was a case that had to go to trial. But Judge Adams had set bail sufficient that his family, which was a respected family in the area, I'd known his brothers. One of his brothers was in my class at school. But he was out on bail pending trial. And I happened to be sitting in the parking lot at Hogan's Hut, and in the car with me was the highway superintendent of North Harmony at the time, Bob Pickett. And we were just talking, and all of a sudden, out of nowhere, appears Jerry Olson, the defendant in the case. And Jerry was a big muskie fisherman, and he always carried this big club, which he would use to disable the muskies so he could get the plugs and hooks out of their mouths. Well, he saw me, started beating on my car, raging that he was innocent, that he didn't do this. And I kept trying to reassure him, Jerry, you've got good counsel. You had Ed Fagan representing him as, I believe, his public defender. I don't know if he was retained, but and it doesn't matter. I said, you've got a good lawyer. This is what trials are about. I said, this is nothing personal, blah, blah, blah. Didn't assuage him at all. And I had a private car then, but I had a police radio that the first thing he did was smash the antenna off the police radio to put me out of communication with any other sheriff's cars or police that might be nearby. So back then, we got out of there. I just left the area before he, reached in and grabbed me or did something. And if you're familiar with the area around Hogan's Hut, back then you could go around, cross the bridge, and come back behind Hogan's Hut, and there's a T intersection. One is the Stowe Ferry Road, and the other one is a road that connects up with 394. Well, Bob Pickett, the highway superintendent, said, John, I left my truck running in the parking lot, and I've got a loaded .38 under the seat, which he had a permit for. And there's Jerry Olson wandering around. The last thing we need for him to have a loaded gun. So we're going to circle around behind Hogan's Hut, see if we can sneak back in the back and have him go get his truck and get out of there. So while we're at this crossroads, I didn't see it, but Bob said he's got a knife. And I looked over, and in the snowbank, Jerry had reached up and picked up a Bowie knife, and I'm not kidding you, it was that big, and he threw it at the car, and it stuck in the divider between the windshield and the driver's window, made a big gash in it, and then fell out. And got Bob to his truck, and we got out of there and ultimately had him arrested, charged with attempted assault or whatever it was. And rather than, I knew it was probably, I wasn't that, I mean, I was concerned about it to the extent that I didn't want anything, I wanted to stay away from him. But after Neil did a good job. I mean, he presented all the evidence they had for the rape, but the jury found him not guilty. And after that, I had Ron Gibb handle the assault case against me. Now, probably we should have had a special district attorney, but I didn't really think it was necessary because I wasn't all that in a twist about it. So Ron Gibb comes to me, and my own assistant district attorney wants to plea bargain a case where I'm the victim.
It was Ron.
It wasn't, yeah, it was Ron Gibb, and we sat down and talked about it, and Jerry was going to go live with his mother in Buffalo, be put on probation, be out of the area, get counseling, do whatever. He'd been acquitted of the rape charge, so we really didn't have anything. And I said, look, I know he was under a lot of duress when he did that. He may have some mental issues because of the automobile accident. And the case didn't go to trial until about 2 years after, I believe, the rape occurred. So I agreed to let him plead to a couple of misdemeanors, and he went and lived with his mother. And several years later, I ran into him. I was actually introduced, not reintroduced, but reintroduced to him by one of the former chiefs of police in Lakewood who had known him for years. And Jerry was very apologetic. He said, I've been meaning to apologize. He said, I was upset at the time. He said, I wasn't myself. And from then on, Jerry and I have been fine. I see him in Mayville. I see him but back in the area now, still fishing. I see him. We get along fine. But that's the only time, other than some letters from someone that I think we've all received correspondence from one time or another. I've never been threatened in all the years as DA or as judge.
Now, in that case, Paul, isn't this the one where they had a show-up or a lineup or a photo array?
Well, Neil can tell that story.
Neil.
Yeah.
Yes, Neil.
I feel like Mike Huckabee in Republican debates. I've been sitting here. My turn? Now that I've got your attention.
You did read the news.
Yeah, I did read the news. The sad thing is, the newspaper's from 1977. I was looking through it, and I know all the people in it. Yeah, there was a lineup in the Jerry Olson trial. The lineup was scheduled at the Chautauqua County Jail, and the victim was a very, very nice young lady. She was, in fact, working on her master's or graduate program at the University of Toronto. And so she came back for the lineup, and somebody had driven Jerry to the lineup, and he was sitting in the car in the parking lot, and she pulled in right next to him, unfortunately, and saw him, and became extremely upset. And she went through the lineup, and I think we had some trouble with that, with the lineup as a result of it. The inadvertent show-up, yeah.
Wasn't Kevin Laumer one of the people in the...
Kevin was in the lineup, yeah. She picked the defendant, didn't pick Kevin.
Despite John Siriano's best efforts, she did not pick Kevin out.
And I got to tell you one other interesting Neil story. Or Neil, can you share that back with the one homicide? And I'm going to tie these all together because I asked Neil what he found some of the strength and qualities of Judge Ward. And but listen to this funny story. Yes, Judge.
You could ask him about Calvin.
I'm going to ask him about Calvin. We'll do that in just a minute. I was going to have him tell the story about when you went to the stabbing victim.
Oh, the Roger Carlson case?
Yes.
Yeah, I was sitting in my office. I worked part-time in the district attorney's office back when that happened, and was in my private office, and the police called and said they had a homicide off Buffalo Street Extension. It was behind where, those you remember, where the Dodge dealership was, and I think now it's the Morton Club. And so I went out there, and I'd never been to a homicide before, but I stood around like they do on TV. We had these badges that we put outside our jackets, so we looked like we know what we were doing. And after hanging around for a while, Lieutenant Manzi says to me, "Well, can we remove the body?" And I said, "Sure, no problem." About 20 minutes later, the district attorney and John and senior investigator Caprino show up, and they said, "Where's the body?" It's gone. So after that, they changed the policy that the body didn't get moved until after the district attorney himself had been there.
Why don't you tell us a little bit about Calvin of Oak Knoll?
Calvin was a interesting fella. He was arrested for murder in the second degree in November of 1979 in the town of Carroll. And prior to that time, he had been a fairly well-known individual in that area. He was intellectually brilliant. I don't know if he graduated from MIT, but I know he attended MIT, and had worked in the computer industry in its infancy in the 60s and 70s. And he had gone and sort of went off by himself. He was quite different, and he formed a church. And this church, which was not recognized by Judge Adams as far as a church or Chautauqua County for real property tax exemption purposes.
No church other than the Presbyterian Church is recognized by Judge Adams.
That's right. And so he formed this society, and they bought quite a bit of land in rural town of Carroll. And there's a couple things Calvin hated. One was tobacco smoke, and the second was deer. Hated deer, and blamed the deer population on New York State and the DEC. And he didn't like deer hunters either. The mere fact he didn't like deer didn't mean he liked hunters. And he had been fairly aggressive over the years. In fact, he had shot some dogs. I think he'd been arrested in the town of Poland for shooting some dogs. There had been some complaints by hunters, woodchuck hunters, that he had taken some shots at them. And he was a very intolerant individual. You couldn't reason with him, and you couldn't talk to him. So his real name was Calvin Klein. I think his father had been a teacher in Frewsburg, and he'd grown up in Frewsburg with Judge Cass's father in that era. And Calvin called this property out in the town of Carroll Oak Knoll. So he became Calvin of Oak Knoll, and his wife Mary became Mary of Oak Knoll. And they lived there in kind of a ramshackle little house, and they had a few followers, although I don't know that anybody else actually lived with them. But on opening day, November 17th, 1979, Douglas Kelly, a businessman from Jamestown, was in his car. He was a businessman. And was in his automobile, and he was driving around in the town of Carroll, and it parked his car on the Sandburg Road, I believe, which is kind of a gravel road. And this road ran right through Calvin's property. And where he parked was a couple hundred yards from Calvin's house. And Mr. O'Kelly got out with he had his shotgun, and he had his hunting vest on with his license, mounted on the back. And apparently, Calvin saw this and went from his house down a hill and up the hill to confront Mr. Kelly. And at that point, Calvin had a rifle with him, which you couldn't use for deer hunting at that time. It was a 30-30 or 30-06, I can't remember which. And some sort of confrontation took place, and Calvin shot Mr. Kelly and killed him right there on the road. Calvin then proceeded to walk back towards his house as he was coming down the hill. A Pennsylvania game protector who was on patrol to make sure that New York hunters didn't get across the line was making a circle back there. Calvin flagged him down, and Calvin said, I shot him. We had an argument. He threatened me or something to that extent. So a couple hours after that, we met the scene with Judge Ward, or District Attorney Ward, and Tony Caprino at that time. And John takes a look around and decided and heard what he heard from the law enforcement and decides, well, Neil, this case will be a good one for you. So,
It was a self-defense case.
and so it was mine. We had a preliminary hearing, and one or two of Kelvin's followers showed up and raised some ruckus there. And then Kelvin retained Bruce Carpenter, and he became indicted, and subsequently Kelvin terminated Bruce's relationship and was represented by Bill Custer. I think the interesting thing about the trial was it did gather a huge amount of publicity, if I recall at the time, or maybe I just kept reading my name in the paper over and over again from the same article, I'm not sure. But it seemed to generate a lot of publicity. And there was, at the trial, going up to pick the jury, I remember there were television cameras in the hallway and stuff, so it was you know, of some interest, and every day during the trial there were headlines in the Post-Journal. Part of that was because the reporter lived in Bemis, where I lived, and I used to give him a ride back every day, so after court. And, but we really had to kind of show that, you know, Kelvin went after this guy, and there were no eyewitnesses other than Kelvin. And so the trick was to make Kelvin, the theory was, to strategy, that's a better word, was to make Kelvin the aggressor. Because, you know, as far, for whatever it was worth, I was convinced, and many law enforcement were convinced, that there's no question in our mind that Kelvin was looking for the proper situation to confront and threaten or assault a hunter, I mean, based on his past conduct. And so I think that's what happened here, and perhaps Mr. Kelly, Kelly, said something that irritated Kelvin, but he just shot him. And Judge Adams didn't think they were going to find him guilty, and the jury did. They got they asked for, they couldn't make their mind up after a couple hours, so they got to spend the night at Webb's Hotel, and came back the next morning and met for about 15 minutes, and 9:30 in the morning came back with a verdict of guilty. So he was when you're trying cases, as you all know, whether you're prosecuting your defense or it's a civil case, in order to do it, at least to give it your all, you have to believe you're right or your position's right completely. And it's sort of that frame of mind you get yourself into. And in my mind, and still today, he committed murder in the second degree, and I think he was a dangerous man. And there are certain people that need to be separated from society as a result of their activities. And Kelvin was certainly one of them, in my opinion.
And he died in jail?
Yes, he died in prison. After
What was he sentenced to?
he was sentenced to 15 years to life, because the proper sentence, in my mind, would have been 25 years to life, and that's what we asked Judge Adams. But Judge Adams, who was convinced he was going to be found not guilty, showed me by sentencing him to 15 to life, so that he had the last word, of course.
Now, we opposed his parole on a number of occasions,
Yeah,
correct?
he actually served more than the minimum before. I think he had served 20-some years in prison, and then he passed away in jail. Kelvin was about 56 or 57 years old when this happened.
And Neil, so over your course of the time working with Judge Ward in the district attorney's office and practicing in front of him as a judge, what are some of the things that stick out about Judge Ward?
Well, as we just discussed, he knew how to get past bad cases. No, I think John and I began working with John when he was an assistant district attorney, and when I had my first traffic trial, John told me to stop at his house and took time off from his brand new baby to sit and tell me every question I had to ask and what to do, and I remember that. But working with John in the district attorney's office, and I'm not saying it isn't that way now, I have no knowledge, but it was a great feeling of camaraderie among everybody there, and we all felt we were doing important things. And that's based on, you know, our boss, John. He was extremely tolerant. He was extremely kind. He would listen to you. If you had a position, he would certainly listen to it, and many times you could convince him of your position. He was, if you made a mistake, and I certainly made many, he would back you. You know, he wouldn't dress you down. I don't ever remember hearing him raising his voice at anybody in the office. And he was behind you the whole way. And I think that John, and this continued into the fact when he became judge, he really took his job seriously, both as district attorney and as judge. He wasn't a politician who was a district attorney or a politician who was a judge. He was a district attorney who had to be a politician at times, and he was a judge who had to be a politician every 10 years. But he made decisions based on what he thought was right in the best interest of the people of this county. And he certainly has been, in his 40 years, a real asset to this county. And of course, I take credit for starting it all, because on May 14th, 1977, the day Paul King died in that accident, I said to John, well, you're going to have to run for district attorney. And so obviously that's why he did it, because I told him he had to.
And it's interesting because the same theme came through with Richard. And Richard, I told you about that case that he tried and he thought that he was going to win, and John won the case. And Richard, I ask you kind of the same question. What were your thoughts on that? About
Case
John.
or about John?
John.
Well, I'll tell you, one of the early cases that John tried, I don't remember if this was before or after I became public defender, but it was a young man who shot two people under very peculiar circumstances. And Bruce Carpenter, yeah, the name was Wilbur. Bruce Carpenter defended, I believe, or Eddie Fagan. I guess it was Eddie Fagan. Fagan defended it. I didn't have anything to do with the case myself, but I remember at the end of the case there was a newspaper article, and John was quoted as saying, this has been a terrible tragedy for both families, the family of the victim and the family of the defendant. And I thought at that time, this guy really gets it. He understands what it is to be a district attorney. That it's not quite the same as being a defense lawyer, where you just get a case and you can pin your ears back and go straight forward. Prosecutors, especially the elected district attorney, are just subject to so much nuance and occupy an almost unique situation in society, and not everybody is cut out for that. And it's been my belief for a very long time, John was built to be a district attorney. I know being a judge is a better job. You run only every 10 years and you get to wear a dress. So, I understand why he made the change, but I think when God drew up the plans, he said, this is going to be somebody that's going to have those qualities. I never had to worry with John as to whether he was telling me the truth or whether he would do what he said he did. I don't think there was ever a crossword between us. We could get very intense in the middle of the courtroom, but I don't ever remember anything personal at all. It was the law, the interpretation, the arguments, and that was it. I think both of us have told this story in the past. One time we tried some sort of case, and I don't remember what it was, but we tried it for about a week. And at the end of the case, Judge Adams said, this has never happened, but according to my notes, there's been one objection by the defense, which was granted, and one objection by the prosecution, which was granted, and no other objections or arguments on the record. We just put the proof in and went with it. And that pretty much was the way it was. Most of the time, we could work things out, not always. Some things had to be tried. Some things had to be resolved, and I doubt that he held anything back. I know I didn't.
Kevin, any
over
thoughts?
those years.
Kevin Laumer?
Well, as a district attorney, John was always a gentleman. As Richard was saying, he never raised his voice, he never screamed, he never got carried away. He was always a gentleman. On the bench, I'm reminded of what Neil said. He would always listen to you. And then from my position, would always rule against me, but he would always listen. Because you see, I was a young, flaming liberal, and nobody ever accused John Ward of being a liberal, you know, so. But, no, he was always a gentleman, and I've appreciated working with him over these years.
Paul?
Ditto.
There was a theory, of course, that John never left the DA's office. he just established a branch office over in the county court.
If I might, Greg, just one thing.
Your
I had
Honor,
not
sir.
been on the bench, I don't know, too long, when Ned Barone was arguing a motion, and I ruled in his favor. And I think he looked at the court reporter and said, then he looked up at me and said, "Hell hath frozen over."
My main, well, actually with Richard and myself, we had John, I worked against John when I was in the public defender's office as an investigator, but we still had day-to-day contact, talked about cases. Then Richard worked against him when he was in the public defender's office. And then we tried cases in front of him as a judge, and I worked for him as the DA. And probably John indicated earlier in the program that he wanted to be an environmental lawyer, but he has spent these past 40 years cleaning up unfortunately, the human debris that comes in our society. And he's done an excellent job. He's done it in a temperate way. He's never had a soapbox that he would get up on and pound, and he did it very effectively. And I have two quotes I will always remember for John. When I was going up to try my first case in county court, he looked at me and says, "Don't worry about the fact that your job is riding on getting a conviction here. Don't worry how you try the case." So obviously, that was probably one of the cases he gave me because he knew what it was going to be like. Both Neil and I had the reputation of not guilty Robinson and not guilty Andrews.
More so to you.
Yeah. And the other thing was every 4 years as elections came by, he would always tell me to feel free to test the limit of campaign contributions. But in the past 8 years, as I've been working with him so closely as law clerk, and a lot of these cases, I can say he was neither DA nor was he defense-oriented. He was law-oriented, and that's how he wanted to be, and that's how he decided everything. So.
Thank you. Well, at the Robert Jackson Center, we often pause and reflect on history and its legacy. I think what we saw today, might be part one of a unique opportunity, a glimpse into the actual judicial process that occurs here in Chautauqua County. I found fascinating. And I must tell you, I'm up there in the cheap seats, not always up there, but nobody moved. I don't know if you guys noticed this, but nobody moved during this last 1 hour and 50 minutes, which is unheard of for lawyers. They weren't flicking on their cell phones. They weren't turning pages. They weren't doing anything. And so that's a compliment to the panel here and Judge Cass. Fantastic way to move this process along.
Good job, Judge.
It was remarkable. Which is a real manifestation of how much work Judge Cass did to go through 5 of the 12 cases that he prepared for, which means we probably have an opportunity to go through the balance of those cases. Maybe in the spring. I'll talk to your agents later. This has been a spectacular, and to honor Judge Ward for 40 years, because but for that fact, we wouldn't have had this opportunity today, and literally the largest crowd of attorneys we've ever had for any continuing education program. So another round for this fantastic program here.